Civics. This course covers what the basic purposes of government are and how modern governments differ from one another. Objectives. Describe the different types of government and give examples of each. Summarize the process used to ratify the Constitution. Describe the three main parts of the Constitution and explain what each part includes. Describe the process for amending the Constitution. Describe the powers and responsibilities of the three branches of the federal government. Outline the process by which laws are made. Summarize some of the landmark cases handled by the Supreme Court. Briefly describe the ways in which state and local governments operate. Explain the rights and responsibilities of citizens in a democratic nation. Summarize the process for electing a President of the United States. According to the Constitution of the United States, the federal government was established for 6 specific purposes. These purposes include unity, justice, domestic tranquility, defense, promotion of the general welfare of the citizens, and securing liberty for all. Many political theorists feel that the primary purpose of government is to protect its citizens, both from one another and from outside attack. Over the years, the concept of protection has been expanded to include far more than protection from foreign enemies. Most people now feel that the government's purpose includes protecting citizens from economic disarray, which can range from protection from individual or household want or loss to protection from the loss of value of the national currency. In addition, government protection also often includes protecting citizens from exploitation, from unsafe or unfair business practices, from consumer fraud or dangerous food and products, and from crime perpetrated by fellow citizens. While citizens at times disagree on the extent to which government should insert itself into the choices and freedoms of some of its citizens, in an effort to protect other citizens, the protective nature of government remains its most crucial purpose. Types of governments. Anarchism. A form of government, or lack thereof, with no ruling hierarchy. Instead, decisions are made at a directly democratic level. Laws are created by citizens alone, although they may be enforced by institutions that are not publicly controlled. Anarcho-capitalism. A stateless society composed of sovereign individuals living within the constraints of a corporatist market. Anarchy. Anarchy is lack of a central government, as there is no one recognized governing authority. In anarchy, there is no effective government, as opposed to an ineffective government. And each rugged individual has absolute liberty. It is important to note, however, that the lack of a government to enforce laws does not automatically imply that there are no laws. Anarcho-capitalism, in particular, posits a form of anarchy with a body of explicit laws. Aristocracy. A form of government in which a select few rule based on inherited hereditary right. Autocracy. A form of government in which the political power is held by a single, self-appointed ruler. Caprocracy. Rule by goats. Without a doubt, the most superior form of governance known to man or to goat. Communist state. A hypothetical stateless entity that follows after socialism, as according to Marxist theory. Corporatocracy. A form of government where a corporation, a group of corporations, or government entities with private components control the direction and governance of a country. Demarchy. A hypothetical political system run by randomly selected deciders, decision makers who have been selected by sortition or drawing lots. Think selecting a legislator or executive in the same manner that a jury is presently selected. Democracy refers to a broad range of types of government based upon the consent of the governed. In its purest form, it is the same thing as democracy, but it is usually practiced in the form of a republic or constitutional monarchy, which provides checks and balances and an establishment that is able to tap an unruly mob on its collective head. In the U.S., democracy is often mistakenly assumed to mean direct democracy as opposed to representative democracy. Despotism, rule by an all-powerful individual, a less polite term for autocracy. Dictatorship, rule by a dictator instead of a despot. Political science is very nuanced. Technically, a dictatorship is where the executive holds a disproportionate amount of power, so an oligarchy can be a dictatorship, as in the case of South American juntas. Epistemocracy, a utopian type of society and government in which people of rank, including those holding political office, are those who possess epistemic humility, whatever that is. Ethnocracy, a form of government where representatives of a particular ethnic group hold a number of government posts disproportionately large to the percentage of the total population that the particular ethnic group or groups represents, and use them to advance the position of their particular ethnic group or groups, to the detriment of others. In Nazi Germany, ethnic groups Hitler supported held all the power. Neo-Nazis often accused Jews of possessing an ethnocracy in the person of the U.S. government, which they call the Zionist occupation government. Exarchy, a form of government, usually theocratic or monarchic, that is established and constituted for rule over an ethnic or religious diaspora rather than over the place of origin whence the diaspora originated. Fascism, rule by a totalitarian and corporatist government. It has also gone by the names Nazism, Baathism, corporatism, and Phalangism. Feudalism, government by a usually hereditary class of military landowners, who exact goods and services from a peasant class in exchange for protection. Usually features complex webs of loyalties and ranks. Feudarchy, system of government proposed by economist Robin Hanson based on the idea of voting on a certain outcome and then figuring out how to achieve it. Geniocracy, a system of government first proposed by Rail, leader of the International Raelian movement in 1977, which advocates problem-solving and creative intelligence as criteria for regional governance. Not, unfortunately, rule by genies, which would be much more awesome. Kakistocracy, government by the least qualified or most unprincipled citizens. Government by the worst. Kleptocracy, a term applied to the government that extends the personal wealth and political power of government officials and the ruling class, collectively kleptocrats, at the expense of the population. Critocracy, rule by those who are strong enough to seize power through force or cunning. Critocracy, rule by judges. Matriarchy, rule by women, or a government which regards female humans as entitled to rule and to exercise power over men. Meritocracy, a government wherein appointments are made and responsibilities are given based on demonstrated talent and ability. usually incentivizing merit. Monarchy, a political ideology which maintains that the state's only legitimate function is the protection of individuals from aggression. Mobocracy or ochlocracy, rule by a mob or a mass of people, or the intimidation of constitutional authorities. Think Monty Python and the Quest for the Holy Grail witch duck mob. Monarchy, rule by an individual for life or until abdication, often hereditary. On a positive note, a monarchy usually possesses more checks and balances than an autocracy or dictatorship. Necrocracy, a government that operates under the rules of a dead ruler. Oligarchy, a form of government in which power effectively rests with a small elite segment of society distinguished by royal, wealth, intellectual, family, military, or religious hegemony. Panarchy, a political philosophy emphasizing each individual's right to freely join and lead the jurisdiction of any governments they choose, without being forced to move from their current locale. Patriarchy, rule by men, or a government which regards male humans as entitled to rule and to exercise power over women. Plutocracy, rule by the wealthy, or power provided by wealth. Republic, historical and international definition. Any of a wide variety of non-monarchical governments where eligibility to rule is determined by law. U.S. definition: rule by elected individuals representing the citizen body and exercising power according to the rule of law. Socialist republic or People's Republic, a state run by a communist party, or worker representative democracy, with a centrally controlled economy and resources distributed by need and produced by ability, where workers or the party control the means of production. Stratocracy, a system of government in which there is no distinction between the military and the civil power. Technocracy, a form of government in which engineers, scientists, and other technical experts are in control of decision-making in their respective fields. Theocracy, a form of government in which a god or deity is recognized as the state's supreme civil ruler. Since said god or deity is usually absent from decision-making, a self-appointed or elected leader or leaders of the religion of said god or deity will rule instead through personal interpretation of the laws commanded by the god in that religion's law, usually a written law. Theodemocracy, a political system theorized by Joseph Smith, Jr., founder of the Latter-day Saint movement, Mormons. As the name implies, theodemocracy was meant to be a fusion of traditional republic democratic rights under the U.S. Constitution combined with theocratic elements. Timocracy, either a state where only property owners may participate in government, or where rulers are selected and perpetuated based on the degree of honor they hold relative to others in their society, peer group, or class. Tyranny, rule by a selfish or otherwise bad single ruler. The ratification process started when the Congress turned the Constitution over to the state legislators for consideration through specially elected state conventions of the people. 5 state conventions voted to approve the Constitution almost immediately, December 1787 to January 1788, and in all of them, the vote was unanimous: Delaware, New Jersey, Georgia, or lopsided: Pennsylvania, Connecticut. Clearly, the well-organized Federalists began the contest in strong shape as they rapidly secured 5 of the 9 states needed to make the Constitution law. The Constitution seemed to have easy, broad, and popular support. However, a closer look at who ratified the Constitution in these early states and how it was done indicates that the contest was much closer than might appear at first glance. 4 of the 5 states to first ratify were small states that stood to benefit from a strong national government that could restrain abusers by their larger neighbors. The process in Pennsylvania, the one large early ratifier, was nothing less than corrupt. The Pennsylvania State Assembly was about to have its term come to an end, and had begun to consider calling a special convention on the Constitution, even before Congress had forwarded it to the states. Anti-Federalists in the State Assembly tried to block this move by refusing to attend the last 2 days of the session, since without them there would not be enough members present for the state legislature to make a binding legal decision. As a result, extraordinarily coercive measures were taken to force Anti-Federalists to attend. Anti-Federalists were found at their boarding house and then dragged through the streets of Philadelphia and deposited in the Pennsylvania State House, with the doors locked behind them. The presence of these Anti-Federalists against their will created the required number of members to allow a special convention to be called in the state, which eventually voted 46 to 23 to accept the Constitution. The first real test of the Constitution in an influential state with both sides prepared for the contest came in Massachusetts in January 1788. Here, influential older patriots like Governor John Hancock and Sam Adams led the Anti-Federalists. Further, the rural western part of the state, where Shays' Rebellion had occurred the previous year, was an Anti-Federalist stronghold. A bitterly divided month-long debate ensued that ended with a close vote, 187 to 168, in favor of the Constitution. Crucial to this narrow victory was the strong support of artisans, who favored the new commercial powers of the proposed central government that might raise tariffs, or taxes, on cheap British imports that threatened their livelihood. The Federalists' narrow victory in Massachusetts rested on a cross-class alliance between elite nationalists and urban workingmen. The Massachusetts vote also included an innovation with broad significance. John Hancock, who shifted his initial opposition to the Constitution, led the move toward ratification. Satisfied that certain amendments protecting individual rights were going to be considered by the first new Congress that would meet should the Constitution become law, this compromise helped carry the narrow victory in Massachusetts and was adopted by every subsequent state convention to ratify, except Maryland. By the spring conventions in the required 9 states had ratified, and the Constitution could become law. But with powerful, populous, and highly divided Virginia and New York yet to vote, the legitimacy of the new national system had not yet been fully resolved. The 3 main parts of the U.S. Constitution are the Preamble, the Articles, numbering 7, and the Amendments, numbering 27. The Constitution was drafted by the Founding Fathers in 1787 at the Constitutional Convention. The Preamble essentially announces the intent of the Founding Fathers in drafting the Constitution, but it does not actually have any legal value in and of itself. There have been attempts by litigants to base legal arguments on the wording of the Preamble, but these attempts have never been successful. The 7 Articles of the Constitution describe the basic legal structure of the United States, including rules and regulations and limitations of powers of the various branches and components. Article 1 describes the legislative branch of government, including the House of Representatives and Senate. Article 2 outlines the presidency. Article 3 describes the judiciary. Article 4 outlines the relationships of the individual states. Article 5 outlines the process for creating amendments to the Constitution. Article 6 deals with the legal status of the Constitution. Article 7 describes the ratification of the Constitution. The amendments to the Constitution acknowledge the evolution of the state over time. The first 10 of the 27 amendments make up what is known as the Bill of Rights. Amendment 13, dating from 1865, enshrines the abolition of slavery. The 18th Amendment, which began Prohibition era with the outlawing of alcohol, opened the doors to organized crime during the 1920s. Overwhelming law enforcement prior to the amendment's repeal in 1933. This was the only American constitutional amendment to be repealed in its entirety. The 18th Amendment took effect on January 17, 1920, after years of lobbying by the progressive temperance movement. Women were the prime movers behind both temperance and women's suffrage and viewed the elimination of alcohol as a key women's rights issue. After a decade of intensifying organized crime, and then the crushing burden of the Great Depression, America decided prohibition was not worth the cost. On December 5, 1933, state conventions overwhelmingly voted to pass the 21st Amendment, repealing prohibition. Thomas Jefferson is considered to be the primary author of the Declaration of Independence, according to America's Library, of the Library of Congress. Jefferson wrote the draft that was considered by the Continental Congress between June 11th and 28th, 1776. Jefferson was part of a 5-man committee that was appointed by the Continental Congress and asked to produce the document. The rest of the committee consisted of Benjamin Franklin, John Adams, Roger Sherman, and Robert R. Livingston. Borrowing ideas that he had read in several documents, such as the Virginia Declaration of Rights, Jefferson wrote the words that would help create the United States of America. The Constitution provides that an amendment may be proposed either by the Congress, with a 2/3 majority vote in both the House of Representatives and the Senate, or by a constitutional convention called for by 2/3 of the state legislators. Our federal government has 3 parts. They are the executive, President and about 5 million workers; legislative, Senate and House of Representatives; and judicial, Supreme Court and lower courts. The President of the United States administers the executive branch of our government. The President of the United States administers the executive branch of our government. He enforces the laws that the legislative branch, Congress, makes. The President is elected by United States citizens, 18 years of age or older, who vote in the presidential elections in their states. These votes are tallied by states and form the Electoral College system. States have the number of electoral votes which equal the number of senators and representatives they have. It is possible to have the most popular votes throughout the nation and not win the electoral vote of the Electoral College. The legislative part of our government is called Congress. Congress makes our laws. Congress is divided into 2 parts. One part is called the Senate. There are 100 senators, 2 from each of our states. Another part is called the House of Representatives. Representatives meet together to discuss ideas and decided these ideas, or bills, should become laws. There are 435 representatives. The number of representatives each state gets is determined by its population. Some states have just 2 representatives. Others have as many as 40. Both senators and representatives are elected by the eligible voters in their state. The judicial part of our federal government includes the Supreme Court and 9 justices. They are special judges who interpret laws according to the Constitution. These justices only hear cases that pertain to issues related to the Constitution. They are the highest court in our country. The federal judicial system also has lower courts located in each state to hear cases involving federal issues. All 3 parts of our federal government have their main headquarters in the city of Washington, D.C. How a bill becomes a law. About 25,000 bills are introduced in each term of Congress, but only 10% become law. These are the steps in the lawmaking process. A bill may begin in either the House or the Senate, except for money bills, which must be introduced in the House. Step number 1. Bill is drafted. Members of Congress, the executive branch, and even outside groups can draft bills. Step number 2. Introduced in House. Representative introduces the bill in the House. Only members can introduce bills. Step number 3. Sent to committee. The Speaker of the House sends the bill to a committee. Step number 4. Committee action. Most bills die here. The committee may pigeonhole, table, amend, or vote on the bill. If bill passes, it goes to Rules Committee. Step number 5. Rules Committee. It decides the rules for debate, and when the bill will come up for debate. Step number 6. Floor action. House debates the bill and may add amendments. If a majority votes in favor of the bill, it goes to the Senate. Step number 7. Introduced in Senate. A senator introduces the bill, which is sent to a committee. Step number 8. Committee action. Same procedure as in the House. If the committee majority votes for the bill, it goes to the whole Senate. Step number 9. Bill called up. Majority Floor Leader decides when the whole Senate will consider the bill. Step number 10. Floor action. The bill is debated, and amendments may be added. If a majority votes in favor of the bill, it is returned to the House. Step number 11. Conference Committee. If the House rejects any of the changes, the bill goes to a conference committee of members from both houses. It works out a compromise. Step number 12. Vote on compromise. Both houses must approve changes made by the conference committee. If approved, the bill goes to the President. Step number 13. Presidential action. The President may sign, approve, the bill, or veto, reject it. If approved, it becomes law. Step number 14. Vote to override. If the President vetoes the bill, it can still become law if 2/3 of both houses vote to override the veto. The Supreme Court's landmark cases. Marbury v. Madison, 1803, 4-0 decision. Established the Supreme Court's power of judicial review over Congress. McCulloch v. Maryland, 1819, 7-0 decision. Established the federal government's implied powers over the states. Dred Scott v. Sanford, 1857, 7-2 decision. Denied citizenship to African American slaves. Plessy v. Ferguson, 1896, 7-1 decision. Upheld separate but equal segregation laws in states. Korematsu v. United States, 1944, 6-3 decision. Upheld internment of Japanese Americans during World War II. Brown v. Board of Education, 1954, 9-0 decision. Separating black and white students in public schools is unconstitutional. Gideon v. Wainwright, 1963, 9-0 decision. Criminal defendants have a right to an attorney even if they cannot afford one. New York Times v. Sullivan, 1964, 9-0 decision. Lawsuits based on libel or defamation must show intent or recklessness. Miranda v. Arizona, 1966, 5-4 decision. Prisoners must be advised of their rights before being questioned by police. Loving v. Virginia, 1967, 9-0 decision. Invalidated state laws prohibiting interracial marriage. Roe v. Wade, 1973, 7-2 decision. Women have a constitutional right to an abortion during the first 2 trimesters. United States v. Nixon, 1974, 8-0 decision. President cannot use executive privilege to withhold evidence from criminal trial. Regents of the University of California v. Bach, 1978, 5-4 decision. Upheld use of race as one of many factors in college admissions. Bush v. Gore, 2000, 5-4 decision. No recount of the 2000 presidential election was feasible in a reasonable time period. Lawrence v. Texas, 2003, 6-3 decision. Struck down state laws that prohibited sodomy between consenting adults. District of Columbia v. Heller, 2008, 5-4 decision. Citizens have a right to possess firearms at home for self-defense. Citizens United v. Federal Election Commission, 2010, 5-4 decision. Corporations and unions can spend unlimited amounts in elections. National Federation of Independent Business v. Sebelius, 2012, 5-4 decision. Upheld the mandate that most Americans have health insurance. Shelby County v. Holder, 2013, 5-4 decision. States and localities do not need federal approval to change voting laws. United States v. Windsor, 2013, 5-4 decision. Federal government must provide benefits to legally married same-sex couples. Obergefell v. Hodges, 2015, 5-4 decision. Same-sex marriage is legalized across all 50 states. Most Americans have more daily contact with their state and local governments than with the federal government. Police departments, libraries, and schools, not to mention driver's licenses and parking tickets, usually fall under the oversight of state and local governments. Each state has its own written constitution, and these documents are often far more elaborate than their federal counterpart. The Alabama Constitution, for example, contains 310,296 words, more than 40 times as many as the U.S. Constitution. State government. Under the 10th Amendment to the U.S. Constitution, all powers not granted to the federal government are reserved for the states and the people. All state governments are modeled after the federal government and consist of 3 branches: executive, legislative, and judicial. The U.S. Constitution mandates that all states uphold a republican form of government, although the 3-branch structure is not required. Local government. Local governments generally include 2 tiers: counties, also known as boroughs in Alaska, and parishes in Louisiana, and municipalities or cities-towns. In some states, counties are divided into townships. Municipalities can be structured in many ways, as defined by state constitutions, and are called variously townships, villages, boroughs, cities, or towns. Various kinds of districts also provide functions in local government outside county or municipal boundaries, such as school districts or fire protection districts. Municipal governments, those defined as cities, towns, boroughs, except in Alaska, villages, and townships, are generally organized around a population center and in most cases correspond to the geographical designations used by the United States Census Bureau for reporting of housing and population statistics. Municipalities vary greatly in size, from the millions of residents of New York City and Los Angeles to the 287 people who live in Jenkins, Minnesota. Municipalities generally take responsibility for parks and recreation services, police and fire departments, housing services, emergency medical services, municipal courts, transportation services including public transportation, and public works, streets, sewers, snow removal, signage, and so forth. Whereas the federal government and state governments share power in countless ways, a local government must be granted power by the state. In general, mayors, city councils, and other governing bodies are directly elected by the people. Citizenship is the common thread that connects all Americans. We are a nation bound not by race or religion, but by the shared values of freedom, liberty, and equality. Throughout our history, the United States has welcomed newcomers from all over the world. The contributions of immigrants have helped shape and define the country we know today. More than 200 years after our founding, naturalized citizens are still an important part of our democracy. By becoming a U.S. citizen, you too will have a voice in how our nation is governed. The decision to apply is a significant one. Citizenship offers many benefits and equally important responsibilities. By applying, you are demonstrating your commitment to this country and our form of government. Next, you will see several rights and responsibilities that all citizens should exercise and respect. Some of these responsibilities are legally required of every citizen, but all are important to ensuring that America remains a free and prosperous nation. Rights: freedom to express yourself, freedom to worship as you wish, right to a prompt, fair trial by jury, right to vote in elections for public officials, right to apply for federal employment requiring U.S. citizenship, right to run for elected office, freedom to pursue life, liberty, and the pursuit of happiness. Responsibilities: support and defend the Constitution. Stay informed of the issues affecting your community. Participate in the democratic process. Respect and obey federal, state, and local laws. Respect the rights, beliefs, and opinions of others. Participate in your local community. Pay income and other taxes honestly and on time to federal, state, and local authorities. Serve on a jury when called upon. Defend the country if the need should arise. The election process begins with the primary elections and caucuses and moves to nominating conventions, during which political parties each select a nominee to unite behind. The nominee also announces a vice presidential running mate at this time. The candidates then campaign across the country to explain their views and plans to voters and participate in debates with candidates from other parties. During the general election, Americans head to the polls to cast their vote for president. But the tally of those votes, the popular vote, does not determine the winner. Instead, presidential elections use the Electoral College. To win the election, a candidate must receive a majority of electoral votes. In the event no candidate receives the majority, the House of Representatives chooses the president and the Senate chooses the vice president. The presidential election process follows a typical cycle. Spring of the year before an election, candidates announce their intentions to run. Summer of the year before an election through spring of the election year, primary and caucus debates take place. January to June of election year, states and parties hold primaries and caucuses. July to early September, parties hold nominating conventions to choose their candidates. September and October, candidates participate in presidential debates. Early November, Election Day. December, electors cast their votes in the Electoral College. Early January of the next calendar year, Congress counts the electoral votes. January 20th, Inauguration Day. U.S. constitutional requirements for presidential candidates. The president must be a natural-born citizen of the United States, be at least 35 years old, and have been a resident of the United States for 14 years. Any person who meets these requirements can declare his or her candidacy for president at any time. Candidates must register with the Federal Election Commission, the FEC, once they receive contributions or make expenditures in excess of $5,000. Within 15 days of reaching that $5,000 threshold, candidates must file a statement of candidacy with the FEC authorizing a principal campaign committee to raise and spend funds on their behalf. Presidential primaries and caucuses. Before the general election, most candidates for president go through a series of state primaries and caucuses. Though primaries and caucuses are run differently, they both serve the same purpose: to allow the states to help choose the political party's nominees for the general election. State primaries are run by state and local governments. Voting occurs through secret ballot. Caucuses are private meetings run by political parties. In most, participants divide themselves into groups according to the candidate they support, with undecided voters forming into a group of their own. Each group then gives speeches supporting its candidate and tries to persuade others to join its group. At the end of the caucus, party organizers count the voters in each candidate's group and calculate how many delegates each candidate has won. Both primaries and caucuses can be conducted as open or closed, or some hybrid of the two. During an open primary or caucus, people can vote for a candidate of any political party. During a closed primary or caucus, participants must be registered with a political party to vote for one of its candidates. Semi-open and semi-closed primaries and caucuses are variations of the two main types. When the primaries and caucuses are over, most political parties hold a national convention during which the winning candidate receives a nomination. After the primaries and caucuses, most political parties hold national conventions to finalize their choice for their presidential and vice presidential nominees. There are two main types of delegates: pledged or bound delegates, who are required to support the candidate to whom they were awarded through the primary or caucus process; unpledged or unbound delegates, or superdelegates, who are free to support any presidential candidate of their choosing.